All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good afternoon. We are here in our case 1 CV17 -0250 Beauchamp versus Gust Rosenfeld. Each side will have 20 minutes to present their argument. Opponent, you may save as much time as you wish for rebuttal, but you'll have to keep track of the time yourself as while we have a clock at the podium. We're recording this argument, so in a few days you'll be able to see yourselves on YouTube. Because we're recording this, please identify your client and yourself when you begin, so we can keep everybody straight. We've conferenced the case, we've read the briefs, we've looked at the records, so we're familiar with the issues. So when you begin your argument, just launch right into what you would look like for us to know. Counsel, you may begin.
Thank you.
Good afternoon, Judge Jones, Judge Howe, and Judge Morse. My name is Melanie Beauchamp. I represent Beauchamp Law Office and myself. Your Honors, with all due respect, and despite the fact it's a pleasure to be back at the Court of Appeals, this case should not be here. Why? Because the case should have gone to state bar fee arbitration. Why? All of Gust Rosenfeld's rights in this case for payment derive from its contract with the client Beauchamp. That contract contained a provision for state bar fee arbitration.
And who would have been the parties to that fee arbitration, counsel?
I'm sorry, sir?
Who would have been the parties to that fee arbitration?
The client and Gust Rosenfeld, and we offered in the trial court to participate as well.
So, contrary to the comments made prior to trial, are you suggesting that the amount of money, the third that was taken out, that you ended up with wasn't the total amount? Because I believe the parties stipulated early on that that was the total amount that should have been taken from the total fee as contingent fee payment, correct?
That is correct with this caveat.
So if the client has already paid the total amount that the parties agree, I would say that they were vulnerable to. In other words, there's nothing outstanding that needed to be decided. The money that was subject to contingent fee payment was no longer in their possession. Why are they parties to that?
I knew you were going to ask that question.
Just didn't expect it this early on.
Well, no, I used to clerk for Justice McGregor when she was on the Court of Appeals and Justice Mueller, so I was ready for the interruption and the questioning quite quickly. The reason why it should have been a state bar fee arbitration is, even though the amount was agreed upon, the division and the way in which the sharing of the amount came along should have gone to state bar fee arbitration with the client involved. And here's why. Gust derived its rights from the contract with the client. We said to them, let's take this to state bar fee arbitration. Gust had a contract with the client. That was what they agreed. They realized they had a remedy.
File a motion in state court to enforce the arbitration provision or raise this issue in some way?
It was raised many times. It was raised many times, and Judge Ray asked them repeatedly. Oh, so
this is not something you raised in your brief. So I'm wondering why you're spending all this time on something that's not in your brief.
It was just the opening of my argument about where their rights arise from.
Okay.
So I was just trying to lay the background.
So you're not making the
No,
argument, you're just providing background.
Correct.
Thank you.
And the reason I want to provide that background is because it's very clear that the contract between Gust and the client is what drives Gust's rights to collect in this case.
And you think fee arbitration is appropriate in a situation where Gust does not have an agreement with Beauchamp, correct?
I think an arbitration is appropriate, and I will tell you,
It required.
I think it was required between Gust and their client. Yes, I do.
Was it required between Gust and you?
There is no contract between Beauchamp and Gust, and that's the point.
But you've got the money that they're saying they get a portion of. So it would be arbitrated between the client who's already paid rather than the people holding the money?
It would be because on May 21st, 2014, Gust admitted it had an adequate remedy against the client, which included arbitration. That was the way the case should have proceeded, was taking the case to arbitration. Instead, Gust did an end dance around its contractual provisions, and again, the only rights that they have against us derive from the rights against its clients to correct. So they did an end run around the fee arbitration provision, took their contract with the client, and imposed it on us.
Because there wouldn't be, I mean, the client really has no interest in this. This is a fight between the two of you, so I don't know how involving the client in the fee arbitration matter would serve anything.
Well, again, what I'm trying to indicate to this court, that Beauchamp and Gust have no relationship except for the relationship that Gust had with the client. That's where any rights in collection Gust had derives out of the contract with the client. Therefore, any rights that it wants to assert against Beauchamp, they have to say, how did that right derive? That right against Beauchamp derove out of, can't be contract, because they never had a contract with us. The only way they can say that the right, they've never had a contract with...
But that's where the unjust enrichment comes from, because isn't that isn't that claim non-contractual in nature?
I'm sorry, sir, I missed the first part of your question.
Isn't the basis of the claim is unjust enrichment between you two, and I'm certainly open to being corrected, but that's a non-contractual claim.
Absolutely, I agree. And that's where I will begin my argument to the court. That's exactly right. There is no contract between Beauchamp and Gust. It is only a claim for unjust enrichment. And that claim for unjust enrichment must fail for the reasons stated in our brief and for reasons which I'd like to share with the court now. First of all, the case law is very, very clear. Gust asserted a charging lien against settlement proceeds that it did not attain for its client. Lewis and Roca, it's very clear. If you did not attain that fund and obtain that fund, then your only remedy is against the client. Gust asserted a charging lien, and the court granted a charging lien.
You're saying that's very clear. What is your authority for that proposition?
Lewis and Roca. It says that for...
It doesn't say that.
Okay.
Tell me, give me the exact
Well, the
language
way I
you
see
think
Linder and Langerman, and I read Linder, Langerman, and Lewis and Roca, they basically say, if the attorney was responsible for creating the fund, then the attorney would have a charging lien.
And isn't that what the trial court found below, that the Gust was 75% responsible for creating that fund?
They participated, but they did not create it. And Langerman makes it very clear that just because services were provided does not mean they created the fund. So the fund has to be a result attained.
So it's not Lewis and Roca, it's now, or I'm sorry, give me the exact language that you think supports that.
In
proposition.
Langerman.
Yes.
So when you read Langerman, and when you pull the language of Langerman out, basically it's very, very clear that when, in Langerman, for example, the client was at a net deficit, and the attorney wanted to get paid from the fund. And in Langerman, the court said, well, you haven't created a fund. You actually haven't really even, for the most part, created value, so we're not going to allow you to attach against a fund. And that's in Langerman, and I'm sorry I don't have that. I'll get to that language. It's in here if you give me a moment. But that's basically what Langerman says. So when you look at it, Gust didn't create the fund. It did participate, according to the trial court, in contributing to the fund. Now,
Well, then why wouldn't it be entitled to the portion of that fund that is attributable to its work?
it would be, but that's where the problem is. And the problem is this, Your Honor, is its work. And here's what we did a breakdown very clearly for the trial court and was made very clear. And this is coming back to why I believe they didn't want to go to arbitration and take the whole case with the client to arbitration where I think it belonged. So I'm coming back to what I want to explain to you. And here's why. The case was in its infancy. They'd filed a complaint, did very little discovery. A deposition was not taken until it left Gust. Discovery was only discovery that was basically taken, refurbed, and then from the client directly, and then produced to the other side. And this is why this is very important, and here's why their contribution, I think, needs to be focused upon. What if we went to fee arbitration? Here's what the fee arbitration panel would have seen. They would have seen almost $50,000 for a 7-page amended complaint. Gust billed that and blocked billed almost $50,000 for a 7-page amended complaint. So when it comes to unjust enrichment, did they start the case in its infancy? Yes. Did they get it past the statute of limitations? Yes, but barely. And when you look at their billing, that's the problem with the trial court's finding. If you thoroughly look at their billing, they're asking to be paid for their work, which is by the hour, by taking the contract and imposing it on Beauchamp and saying, Beauchamp has to pay us an hourly rate for our work, which adds up to $50,000 for one complaint, $22,000 for corresponding with opposing counsel, and $24,000 for talking to experts. That's $100,000. And the court said, Beauchamp's going to pay your hourly rate for that. That's the problem.
Didn't John Ager and the judge disagree with your approach that you're taking here? John Ager sat on the stand, came up with a sum of money and said, this is really the fair value based on my review of the records. Hold on. And then the judge does his independent review and ultimately says, yeah, I agree that it's right there. So the judge did a detailed evaluation of the expert testimony that was provided, and I don't remember you guys countering that.
We did, and we indicated that the value of the case is not based on them taking their hourly fee agreement. We constantly told them, we are not the Bialabox. You are taking the Bialabox fee agreement and making us a party to the contract, which is contrary to Wang.
I don't think that's the way the earlier cases, I don't think contingent fee agreements traditionally have been looked at. It's not an all or nothing situation. To the extent that a percentage of the work is determined to have been done by a particular client holding a contingent fee agreement, traditionally they've been able to collect on that by submitting their lien and pursuing it that way. But we're not doing that now?
They can collect against the client on that, but they can't collect against the...
Collect it against. You keep saying Beauchamp has to pay the rate, but you and Gus both agreed during pretrial. Client is on the hook for 1/3, and now we have to figure out who gets the remaining third, or who gets that third. So
correct.
Why? What's your?
In collecting from the 1/3 and dividing that pot, the proper measure of damages for unjust enrichment is the amount of value that is left over.
That's the question, is the value. You operate under the assumption that we're entitled to that 1/3, so anything that's taken out of that 1/3 is taken from us. But it's really, there's a pot of money, and the court looked at it and said, based upon the value provided, you get 25%, they get 75%. So they didn't take anything from you, they just determined what percentage you were entitled to.
And I understand what you're saying, but what I'm saying is they used the wrong measuring stick. And I have 7...
Challenge the factual findings in your appeal. You didn't challenge the court's factual findings regarding the 25-75 breakdown.
I did challenge the measure that they used, and I will address that in my 7.5 minutes left. But I did challenge in my brief that they used the wrong measure of damages, and that's what I would like to get to in my last 7 minutes and 15 seconds.
Okay.
Thank you.
Counsel, you may
Good afternoon, Your Honors. I'm Charles Workin. I am a member of the law firm of Gust Rosenfeld, and I am also general counsel to the firm of Gust Rosenfeld. And therefore, I'm representing the firm this afternoon, as I did in the trial proceedings and at trial. A simple summary of my argument is that the trial court's decision is supported by the record and by the law.
Well, because I was going to ask your opposing counsel, and I will when she comes back up, but as far as the factual determinations of how much the case was worth and how that's to be divided, what's our standard of review in examining that claim?
In evaluating the unjust enrichment claim here, I believe that for the most part, you would apply a clearly erroneous standard if the findings of fact had been challenged, but they were not. And so those findings must stand without contest. And the factual issues, the unjust enrichment claim, for the most part involved factual determinations, whether there was an impoverishment, whether there was an enrichment, whether there was a connection between the two, whether there was any lack of justification, and whether there was a lack of legal remedy is a legal question that you would review de novo. So what I would accept that from the application of the clearly erroneous standard. With regard to the proper measure of damages, I think that's also a legal question that you would review de novo, but the law is well settled that the proper measure in an unjust enrichment claim is quantum meruit. So I don't think there's really any debate about that.
Mr. Workin,
yes, Your Honor.
I have a question. I'm having a little bit of struggle getting all of the right pegs in the right holes here. The parties stipulated, or at least they both asserted or agreed, that 1/3 of the total take, the settlement, was going to be the attorney's fees.
Correct.
The 1/3 was then communicated to the offices of, I'm never going to get this pronounced right, but Beauchamp, your opposing party's firm, correct?
Yes.
Does the simple fact that they've got it in an account mean that it's their money?
No, it's the client's money.
And you've said that the findings of fact of the trial court have not been challenged.
Correct.
Part of what the findings of the trial court are is that 1/3, which both party agrees was subject, I think, to the court's award in some amount. Fair? I may not have said that very well, but that was going to be paid to the attorneys, and that was the only sum that was going to be paid to the attorneys. So they didn't have any recourse to go back to the parties, did they?
No.
Could you have gone back and said, well, you paid 1/3 to them, but you owe another 1/3 to us?
No, especially not given that stipulation. Let me tell you what happened in front of Judge Ray. And, this action was begun by, can I say BLO, the Beauchamp or Beauchamp Law Office, was begun by BLO against only the clients as a declaratory judgment action. The next day, the clients filed their own action asserting several claims against BLO. The two cases were consolidated. The BLO complaint was then amended to name Gust Rosenfeld and also Melanie McBride, who was my former partner, who had left the firm with the case at the end of 2012. So now we're all together, and BLO is represented by its counsel. Mark Harrison is representing the clients. Ms. McBride, I can't remember who her counsel was. I think it was Chris Engel. And Dick Siegel and I are representing Gust Rosenfeld. Mark Harrison moved the court pursuant to Rule 59 or whatever it is regarding declaratory judgment actions for a speedy hearing. And Judge Ray brought us in for that speedy hearing. And he asked us from the bench if we all agreed, and this is in the transcript, do you all agree that these clients should not pay more than 1/3 in fees? And I left out the fact that at that point of the pleadings, Gust Rosenfeld had cross-claimed against the clients for declaratory relief. And the judge asked us, as I said, do you all agree that these clients should pay no more than 1/3? Their responsibility should be limited to 1/3. And we all agreed, everyone, every party that was in front of the court at that time.
Which would have left 2/3 to the clients as their, if you will, gain on the settlement.
Yes.
It just feels to me an awful lot like what we're hearing is that there are 4/3, and that the BLO gets their third, and you get whatever you can get out of the second third, and then the last 2/3 belong to the client. I mean, the math doesn't work.
Well, yeah, and at that point, the client only had received 1/3. BLO had taken 1/3 for itself and expended that money, distributed it, and was holding another 1/3 in trust. And BLO was wanting us, and still today is wanting us, to proceed against the clients, to take money away from them when the money that they agreed to pay for these services was taken by Beauchamp as a fee and spent, and all that's really the recourse should only have been and only is against BLO, and the question becomes, how do you divide that third? And that's really what the most of the trial was about.
What's your best response to Ms. Beauchamp's argument that a charging lien cannot be applied except by the attorney who actually negotiated the settlement or obtained the judgment?
Well, that doesn't make any sense, and it's not supported by the case law. And if this court were to adopt such a rule, it would defeat the purposes of a charging lien. Those purposes are to secure payment for the lawyer and to keep a client from abusing the client's right to freely choose its own lawyer. And if the lawyer who takes the case on a contingent fee basis and works up the case didn't have a charging lien against the ultimate fund after that lawyer is discharged, then a client could engage in some gamesmanship and allow that lawyer to work it up. Let's say hypothetically that the lawyer A takes the case on a 1/3 contingency and works the case up to near completion, but there's no fund yet that exists, and then client discharges lawyer A and goes out and hires discount lawyer B at 25%, who
you said
takes
discount as if it's a bad thing.
Pardon?
You said discount as if it's a bad thing.
I didn't mean to give it that connotation. I'm sorry. The lawyer in town who advertises with that tagline is a good man, and I don't demean him. But hires a lawyer at a discounted fee, at a reduced fee, Your Honor, of 25%, and that lawyer has this case that's packaged and ready to go to settlement or trial, and it is settled, and there's a fund then that comes into existence, and that lawyer gets 25%, and that client, by doing what I just described, saved 8%. And the lawyer A has no claim against that fund. That makes no sense.
Let me follow up with that, because it appears to me, I don't know why it matters in this case, whether the charging lien was valid or not, because it sounds like the parties, Ms. Beauchamp distributed the money that was the 1/3 we're now arguing about for fees. And we return the other 2/3 to the client. So whether there's a charging lien or not doesn't seem to have any impact on whether there's damages under unjust enrichment and quantum merit that are applicable to you all. So I don't know why we would necessarily have to resolve that issue of whether it's appropriate for you guys to have levied a charging lien or not.
Well, that's a different view that none of us have thought of yet.
Well, I don't mean to put you on the spot, but I'm going to put you on the spot. Am I missing something? Because, I mean, there is no pot left that there's a lien attached to, right? You said she's distributed the 1/3. The 2/3 are in the client's hands, so why does the charging lien matter?
Well, it matters in this way, Your Honor, and I think that Judge Anderson agreed in his ruling on my motion for summary judgment, and I think that Judge Ray, in his declaratory judgment ruling, and I realized that there wasn't actually a judgment with Rule 54 language in it, but his minute entry ruling after that speedy hearing, both of them came to the conclusion that the lien attaches to the fund. And as I have said, and as I think Judge Anderson said in different words, the lien follows the money. And so, even if Beauchamp, as she did, took the 1/3 fee and expended it, we still have a lien and it follows the money. If it was in her trust account, great. But if she moved it into her general account, we get to follow it there. If she moves it into her personal account, we get to follow it there. And for that matter, if she went out and bought a new Porsche with it, we could attach the Porsche. The lien follows the money, and I think therefore follows its proceeds. But as it turned out in this case, when faced with the requirement to make certain financial disclosures, she put money, not the same dollars, but she put the same amount of dollars on deposit with the clerk's office.
Okay.
From which we were then compensated after the judgment was entered. And the judgment was satisfied.
Okay.
Okay.
Thank you for answering my question.
Thank you. Because counsel didn't get to her other points, I'm still waiting, and I don't know what to rebut.
Well, I think what you reserve time for is to discuss quantum merit and the calculation of damages. So.
That should have been done up front. I'm happy to rest on my briefs, and I'm more than happy to entertain your questions.
Counsel, let me ask you this one question. You've asserted to us that basically one of the standard of review is abuse of discretion as to regards the standard of review in regard to the order the court eventually entered, is abuse of discretion. Is that right?
No, I did not.
What did you say? I'm sorry.
I think for the most part, if these findings had been challenged, of course the standard would be clearly erroneous. The findings were not challenged, and at least a couple of issues here, or pieces of the issues, are legal in nature, and whether there was an adequate remedy at law, which is the fifth element of unjust enrichment, is a question of law, but that hasn't really been challenged here either. What is the correct measure of damages is a legal question to be reviewed de novo, but although it is argued to be some other measure, I haven't heard what that other measure is. And any other measure that is articulated here other than quantum merit is simply legally incorrect. So I don't think there's any abuse of discretion at play in this case unless you get down to the level of arguing about the sanctions for the non-disclosure of a draft letter and a draft agreement with the client.
Which the judge found to be irrelevant.
Correct.
Thank you. I don't want to take all the rest there. You seem to be allowed to keep that.
So I think that today's argument and the briefing that you've seen from appellant illustrates that this is a frivolous appeal. There is nothing to it. And I think that is a situation that warrants your attention and the imposition of some sanction under Rule 25. And I touched on this in the closing page of my brief. Much like in the Johnson case that I cited to you, where the findings are not challenged and the findings really govern and drive the outcome of this case. And what remains, to quote from Johnson, is a confusing array of assertions, variously and at times simultaneously foisted upon incorrect propositions of law and completely unsupportable legal conclusions, unquote, is much what we have here. There's been disregard for the standards of review. The findings of fact, although unchallenged, have not been faithfully honored in the arguments. In fact, they've been disregarded. And it's been suggested to this court that Gust didn't create any value because it didn't recognize the fertility issue. That was denounced by Judge Kiley in his findings. It's been said to you that the case was taken by the Beauchamp firm after having been told by the client that Gust had told the client it was not going to assert a lien. And you are cited to a page of the transcript, and I invite you to go read that on the transcript of December 7th at page 41, which is cited to you at page 4 of the opening brief, and it is misrepresented to you.
Well, didn't the trial court made a finding specifically that the allegations that Gus had ever said that were not credible? Isn't that correct?
The trial court dissected those assertions and found Ms. Beauchamp and Ms. Neese to be unbelievable. But yet, still in the briefing, you hear argument about what happened at the June 5th, 2013 meeting in my firm's office, which was really a meeting about a different case, not this one. And then you hear also argument about some other measure of damages that simply doesn't have basis in the law. I agree with Ms. Beauchamp, we shouldn't be here today. And the reason why we shouldn't be here is that there should have been no appeal. There is no basis for an appeal. It is frivolous. And unless you have further questions, I will retire.
Thank you, counsel.
Thank you, Your
We
Honors.
appreciate your argument. Counsel?
Thank you. This appeal is not frivolous. I do have the pinpoint cites to Langerman if the court wants them. That is Langerman 204 P3rd 1103 and Correa, which is 780 South 2nd page 220. It is not of this jurisdiction. It's in Florida. Your Honor, this is not a frivolous appeal. The June 5th letter, excuse me, the July 24th letter, where we were first informed that Gus intended to make a claim, is really important, because why would they send a letter on July 24th if they told us on June 5th they were going to take a lien? They sent the July 24th letter because they knew they weren't. We took this and other cases from Gust, McBride, etc. This was one of the cases that happened to be fruitful. All of the other cases we put a lot of money in an attempt to help the clients, and actually were upside down. So when Gust indicates that somehow we have ulterior motives and we shouldn't be here appealing, we should be here appealing. And if you look on page 22 of our brief, it's very, very, very clear that what we said is it's the wrong measure. And we cite Dobbs' Law of Remedies. Quantum merit and unjust enrichment are two different ways of measuring damages. Quantum merit says a contract. We all agree there was no contract. So we look and see what was the value. I'm going to get my house plumbed. I have a terrible plumbing problem. Plumber number one comes along, starts the job, kind of gets it going, leaves some bricks, leaves some mortar, gets the job started, and abandons it, is fired by the client. Plumber number two comes along, that's Heimson Pentiliot. They do a little bit, they don't know, they're gone again. They just leave. The homeowner fires them. Plumber number three comes along, McBride. Really didn't do very much on the case, didn't advance it, still not a deposition taken until it got to Beauchamp. Fired by the homeowner again. Homeowner says, I want somebody to finish this job, it's a mess. This job was in its infancy. We had a complaint, a 7-page amended complaint that was still defective, as you can see by the record, and Wynn Salmon's telling McBride, this doesn't even make any sense. But a $50,000 charge for which the trial court allocated funds to Gust. Gust says they're experts. $50,000 for a 7-page amended complaint. The trial court gave it to them out of the fund. $24,000 to talk to their experts. This is all on the record. This is all raised.
They're all findings of fact by the judge.
Correct.
So you're asking us to reconsider the findings of fact
No.
of the judge?
I'm using that as an example that it's the wrong measure of damages. The measure of damages is not how much Gust may have put into it and the time they may have put into it. It's the reasonable amount and the value of the services. It's the value of what the plumber left on the property undone.
Well, but
That's the proper measure, and we argue that beginning on page 22 of our brief.
but counsel, the trial court is perfectly within its rights to say that what the attorney charged is approximately the same or the same as what the case is worth, and if that's the case, we would have to find that determination to be clearly erroneous, and I'm concerned about how we can find that.
It is clearly erroneous because they used the wrong measure. They imposed this contract and its hourly terms onto an unjust enrichment claim. Wang says you can't do that. They made us an unwitting guarantor of the terms of that contract. Wang says you can't do that. The proper measure is what was their loss.
Well, what would happen if the value of the services that Gust claims happens to be the same amount as what the court determines to be the value?
But what we're arguing is they can't because they didn't apply the correct standard. And if you look at what Gust did, it was a complaint, defective complaint in its infancy with no depositions, no motions, and little to no discovery. And that's why.
I'm sorry, go ahead.
I'm sorry, and that's why we are saying to you, and we're saying the court used the wrong measure of damages for an unjust enrichment. They're imposing a contract and using that measure, and that's not the correct measure. And what makes it more outrageous is when you look at $50,000 for a 7-page complaint, it becomes even more clear that that's the wrong measure, because the proper measure is what was truly the defendant's loss? What was truly the first plumber's cost in the job? The first plumber started the job and left some materials there. Plumber 2 couldn't finish it. Plumber 3 couldn't finish it. Plumber 4 came along and finished the job. So if you objectively go back and you say, what value did they create? The only value they created was they kept the statute of limitations alive. And that is why we're saying.
But that's not what the trial court found. The trial court found, and they did it both ways. They first calculated it according to the value, but they also said, and the testimony was somewhat unrebutted from their expert, that they were 75% responsible for generating this settlement, and not just based upon the numbers. He did it frontwards and then worked back and said, look, it ends up being the same either way. But how do you respond to that, especially when you haven't challenged the factual findings of the trial court below? You challenged the theory, but not the finding.
Well, we're saying that the trial court found that there was a 75% finding that they were 75% responsible, but we're saying that had they looked clearly at unjust enrichment, that was not the right way to analyze what had happened. That 75% doesn't make any sense, because that's not what the theory of unjust enrichment. Unjust enrichment looks at a lot of factors, and we know what those 5 factors are. And we're saying in coming to that 75%, they neglected to look at all 5 factors. Gust had other remedies. They need to look for enrichment without justification. Well, we were justified. We had a contract. We picked up a mess. We took the risk. They didn't calculate that risk. We could have come out with 0. If you take the trial court's theory and their calculations as given, even if we got 0, we still would have had to pay Gust. That's the problem with the calculations. The theory and the application is wrong.
Counsel, your time is up.
Time is up. Thank you very much, Your Honors.
Thank you, counsel.
We appreciate your argument today, and we'll take the matter under advisement and issue a decision in due course. We're going to stand in recess and remain on the bench while the next case comes up for argument. Thank you.